Good day, students, again. My name is Tata Shikongo, your tutor for Certificate in Policing, Investigative Principles 1A. This is an examination-based conduct class, preparation for August examination. I want to give you a scope of the examination. We start with the introduction, aims of the conduct class, structure, examination and paper assessment, the course outline and the scope, and in the end the conclusion. My qualifications: a BTech forensic degree, certificate in forensic audit, a fingerprint expert, attend various specialized training courses. The aims of the conduct class: preparation for August 2017 examination, best possible chance to do well in your exam, provide a framework for preparation, continuous assessment, calculation of marks, the question paper structure, the mark allocation, questions level of difficulty, verbs level. The continuous assessment, calculation of marks. A continuous assessment per the module consists of one assignment of 120 marks for modules of 12 credits. A 50% continuous assessment mark is required for admission to examination. The duration of the examination for 12 credits is 2.5 hour written examination of 120 marks. A final pass mark of 50% is required, calculated by 60% of the examination mark and 40% of the continuous assessment mark. A sub-minimum of 50% must be attained in the examination. An example is, suppose an assessment mark of equals to 50% or 50 marks. Examination mark is 50%, which is divided as 40% of the 50 equals to 20, as 60% of 50, which is 30. The final mark is 50 marks. The setting and marking of the examination papers are moderated. The structure of the examination paper. The examination paper is divided in 4 questions. The first question is 60 marks. Second question is 36 marks. The third question is 12 marks. And the fourth question is 12 marks also. In total is 120 marks. The scope of the examination. Feedback to complainant about cases and preparation, witnesses to give evidence in court. Detail on the note handed to the complainant should consist of: one way of doing that, keeping the complainant positive, is to hand him or her a note with the details of the case. On such note must appear the name of the station, the case register number, and the telephone number of the police station. The effective police treatment of victim, complainants, to maintain a positive image. The police are mandated under the Police Act of 1990 to investigate crimes or alleged crimes. Investigation of crimes becomes important when the normal crime prevented measures are not effective and the criminals are not arrested immediately after crimes are committed. The low tracing rate of suspects has a negative impact on the negative image of the police amongst the community. Effective investigation and positive attitude of investigators could influence the view of the community positively. Positive and regular feedback to the community could change the negative view of the community. The effective police treatment continues. The measures and actions. Normally, the investigation into a matter starts after a crime has been committed, with the purpose to restore trust by means of effective investigation techniques. Investigators are normally not involved in crime prevention, but with a proper attitude and good communication with complainants, they can influence the attitude of the community. Positive and good communication with community starts when the case is opened. To testify in court has an emotional impact on a witness. The possible reasons are: everybody has a natural fear of the unknown and being treated with hostility. They become nervous and unsure of themselves when giving evidence for the first time. Nervous about being cross-examination. Fear reprisal from the persons they are giving evidence against because they fear that person will come after him or her family. Seeing the offender again may intimidate or influence the quality of evidence furnished by the witness. This may result in the witness breaking down. All witnesses are emotionally touched when testifying. They have to relive something that has happened sometimes years ago, which makes them having to remember the emotional trauma. Things they most probably will have liked to have put behind them by now. Phases of examination. We have examination in chief. It is the first phase of examination that starts after oath is taken in court. During this phase, the witness will testify on his or her involvement as a witness in the case. The prosecutor is supporting the witness and will use the statement made by he or her to formulate questions. The purpose of examination in chief is to tell the court what the witness has seen the day the crime was committed. The purpose of cross-examination is to clarify points that came out during the evidence in chief and test the correctness of the evidence. During this phase, the reliability of evidence and all facts under dispute should be tested. Any witness can be subjected to cross-examination. No provocative question should be posted. The second phase, re-examination. During this phase, the party examines his or her own witness again to clarify points that came up during cross-examination, because it might damage the case of the party it can only take place if there was a cross-examination, limited to the fact that came to the fore during cross-examination. Difference between identification and individualization. Identification, it is of lesser value than the concept of individualization because it is only identifies an object to a specific class or group. Individualization is the forensic scientists will continue with their analysis to determine if a particular sample uniqueness even amongst other members of the same class. Comparison is drawn with another and is used to establish that a dispute sample, when compared, is from the same origin. For example, a fingerprint found at a crime scene can be placed into a group, for example, a wall or a loop identification. Now, if a fingerprint so identified is individualized to one unique person, we talk of individualization. Individualization adds significant value to the concept of identification, since one can individualize a person or an object to identify the origin of the physical evidence found. Now, there are different categories of identification. We have namely the situation identification, witness identification, victim identification, imprint identification, culprit identification, origin identification, and action identification. Now, analysis of the investigation and reconstruction of crime scenes. Purpose of crime scene reconstruction. The crime scene reconstruction is the investigation attempt to determine the sequence of events that constitute the crime. It is therefore the endeavor of all the role players to draw a picture of what may have happened. It involves a combination of different things, such as objects and persons. The way to accomplish this goal is to collect as much evidence as possible from the scene and the suspect. The purpose of crime scene reconstruction. Often, the crime scene officer won't know which piece of evidence will be the key until you have all the pieces together. One of the keys to dealing with evidence is to understand of available technology and knowing the own limit of the crime scene officer. While some evidence can be processed at the scene, other evidence needs to be processed at your local or state crime lab. For instance, the crime scene officer can use a blue star and luminol at the scene to detect blood and other body liquids or fluids. But lab experts need to test the samples. Purpose of crime scene reconstruction continues. The same is true with fingerprints. The crime scene officer can dust and lift for prints, but anhydrine is used back at the laboratory There are many aids available to assist in the reconstruction. Crime scene reconstruction consists of the following venues of event determination: the crime laboratory, crime scene analysis, a verbal testimony versus physical evidence, physical reconstruction, mental reconstruction. When reconstruction is being done, it is important to pose a major question, and where minor questions need to be answered before major ultimate questions is answered. These questions must be posed correctly in order to achieve the goal of a correct crime scene reconstruction. The major questions might be: is this a suicide or a murder? With some of the following minor questions: can the final position of a firearm and the victim be explained? The safety measures are essential in processing a crime scene. Latex or nitrile gloves. These gloves are of course important for protecting evidence because they keep the crime scene officer from leaving his own fingerprints behind. They also offer protection from blood and other hazardous substance at the scene, as well as cuts and liquids. More than one layer of gloves could be worn, and a layer of gloves could be removed when working with different evidence. Footwear. It is also important to protect the scene, which cover the safety shoes of the crime scene officer. Depending on the situation of the crime scene officer, he may use eyes glasses, goggles, or face shield to protect his eyes from chemical splashes, fumes, or something bouncing into his eyes. Respirators with proper filters for arson scenes and meth labs. Masks in cases where there is air is filled with noxious odors from a decomposing body or other biohazards that makes it hard for you to do your job. The Tyvek protective suits for a complete protection which will keep biohazards off your skin. Upon arrival at the crime scene, what is the immediate task of the crime scene officer? He must evaluate the legal ratification of the search, obtain a search warrant if necessary, be alert of discarded evidence when the scene is approached, speak to the first responding officer regarding scene observation, evaluate the path of entry and exit to the scene to be utilized by authorized personnel or laity at the crime. Establish a secure area within the proximity to the scene for the purpose of consultation, equipment, staging, and evidence storage. Upon arrival at the crime scene, what is the immediate task of the crime scene officer? He must also determine additional investigative resources, ensure continuous crime scenes integrity, ensure that witnesses are identified and separated, ensure preliminary documentation, photography, injured persons, vehicles, and etc. Determine the extent to which the scene is protected. ensure that the scene is safe and secure. Now, analysis of the investigation and reconstruction of crime scenes. Responsibilities of the first responding officer to the crime scene is under the following headings. Recording of information. Take control of the crime scene. Secure and protect the scene, focusing on the immediate area. Record as much information as possible despite the condition and scene is found. For example, chaotic due to injuries, loss of lives and witnesses and other people present. Note everything from the treatment of injured to the apparent nature of crime. What was seen, what was done, and who was there. Make mental notes as you make visual inspection of the scene as well. If possible, take unobtrusive photos of any crowd of people. This record may be used by the investigators to decide on the way forward. Prosecutors on how to prosecute, and by defense lawyer to ask questions to the police actions. Now, dealing with witnesses. Dealing with victims is first priority, but dealing with witnesses is a close second. As quickly as possible, identify witnesses and keep them at the scene. Witnesses often have second thoughts, so opt for a thorough questioning at the scene. Keep witnesses separate to avoid collaboration of testimony. Memories, fate, and other issues may influence the decision of witnesses to cooperate later. Communication with others involved. The first responding officer is tasked with getting the ball rolling, so speak. He contacts the region with details of what he has and what he needs. His estimation of manpower and expertise to properly process the scene is the key to investigating the crime and prosecuting the perpetrator. Once additional crime scene officer arrives, the first responding officer should explain everything to say and everything he did. The crime scene officer has many tasks. He must record upon arrival on the crime scene, the time of arrival of the crime scene, the method of scene security such as officers, the barrier tapes, vehicle, and etc. The particulars of everyone on the crime scene such as first responding evidence, the collector and investigating officer. You also consider the weather conditions, the scene temperature, both inside and out, the wind, direction, speed, any precipitation, and condition of the sky. The purpose and consideration of arrest, under arrest and warrant of search. Arrest is one of the methods by which the accused present can be secured in court for the purpose of trial. As a general rule, the purpose of arrest must be to bring the accused before a court to be tried on the charge that he has been brought against him or her, not to punish such person. Police officials must remember that an accused person is presumed innocent until proven guilty in court, and should therefore be treated as innocent as far as it is possible to do so. Arrest should therefore be a last resort. The procedures that has governed the application of issuing a warrant. Section 43, subsection 1 of the Criminal Procedure Act provides that the following person may apply for a warrant: a director of public prosecution, a public prosecutor, a commissioned officer in the police. The application for issuing the warrant must be in writing and must contain the following information: the crime that was allegedly committed, that the crime was committed in the area of jurisdiction of the court concerned, the procedures that govern the warrant of arrest, that the crime was committed in the area of jurisdiction of the magistrate in whose area the application was made, or where the crime was committed within the area of jurisdiction concerned, that the person concerned is known or on reasonable grounds suspected to be within the area of jurisdiction, that based on the information obtained on the oath, it is reasonably suspected that the person concerned committed the alleged crime. He following persons may issue a warrant: the magistrate, a justice peace, commission or commission officer of the police rank, above inspector. Methods of arrest. An arrest occurs when a person is taken into custody and thereby deprive his or her freedom of movement. When the arrest occurs, the right that the person has to privacy and human dignity are also seriously infringed. Section 39, subsection 1 of the Criminal Procedure Act provides two methods of arrest. The one is with a warrant, the other is without a warrant. Although Section 40 of Criminal Procedure Act authorizes to execute an arrest without a warrant, in certain circumstances only the majority of arrests are performed without a warrant. The requirements of a lawful arrest. The arrest must be duly authorized. The officer making the arrest must either be in a possession of a warrant of arrest, or the provision of Section 40 of Criminal Procedure Act must be applicable in case of an arrest without a search. The person being arrested must be taken into custody physically. His or her freedom of movement must therefore be restricted. His or her body may be touched, or if necessary, force may be touched, or if necessary, force may be used to bring the person under control. Merely saying to the person, "I arrest you," will be sufficient. If the arrested person clearly submits his or her custody to the touching of his or her body unnecessarily, the person must be informed at the time of the arrest or immediately after the arrest has been made. The precise words of the charge do not have to be communicated to the arrested person. All that is necessary is that the instance of his or her conduct led to the offense must be conveyed to the arrested person. The arrested person must be taken to the prescribed authority as soon as possible. Section 50 of the CPA provides that an arrested person must be taken to a police station as soon as possible. or if the arrest is performed in terms of a warrant to the place mentioned in the warrant, the arrested person may also be detained for up to 48 hours before he or she must be brought before a court. The arrested person must be informed of the rights of arrest and detained person. These rights must be explained to him in his or her language that he or she understands. The functions of investigator during the trial: sit next to the prosecutor during the trial, take notes, and advise the prosecutor on the questions to be put if any is left out. An investigator who is present during the trial will have an opportunity of learning what evidence to gather in investigation of a particular matter. During the trial, investigators can assist the prosecutor with the exhibits and making the witness available to testify. Subpoena of witnesses and investigators attending court. Procedures when serving a subpoena. A copy of a subpoena must be handed to the witness personally at his or her place of residence, business address, or any place where he or she is employed. If the witness is not available at the address mentioned on the subpoena, a copy can be handed to a person who seems to be not younger than 16 years, who appears to stay or work at the address. If the witness avoids the serving of the subpoena by keeping the business or home address locked, and by doing so making the serving of subpoena impossible, it is sufficient if the copy of the subpoena is attached to the outside door or main door, the residential or business place. The physical appearance in court. Physical appearance in court is very important when testifying. The reason for that is it is crucial to have a good appearance in court to testify. Very crucial bits and pieces of behavior is lost if it is not done. Appearance allows the court to take into consideration the demeanor of the witness in evaluation of the evidence. The presiding officer, as well as the prosecutor and the defense attorney, from certain opinions about the witness according to their dress code, and it is also determined to a certain extent their reaction or demeanors towards that particular witness. Completion and writing up of a case docket. We have page 1, the front page, which have the following details: the case number and the station, investigating officer, the space for date and time of offense, the value recovered, the final results of trial, the exhibits, and disposal of docket. The page 2, section A of the case docket. The first information of a crime statement and all statements by witnesses. All documents the prosecutor will use to build his or her case or to present in court will be filed under this section. Page 4, section C, investigation diary of a case docket. It contains the following information: full working record of all the investigation done in the case, The diary must also be marked with the name of the station, the case number, the index number. It is important that the diary is kept daily and be written up without delay. Page 6, the back page of the case docket in terms of remand dates, bail, admissions, defense, list of witnesses. In conclusion, framework of exam investigation require that you know and understand all concepts and the techniques. One fact, one mark allocation. Number your facts, use bullet points, avoid dumping relevant or irrelevant facts simultaneously. The marker searching for the correct answer. Follow the instruction closely. Use your best handwriting. I wish you all the best with your preparation for exam. My contact details 081-2488-499. Email address titushikongo@yahoo.com.